On January 29, 2022, Boston police officer John O'Keefe was found unresponsive outside the home of a fellow Boston police officer in Canton, Massachusetts during a severe snowstorm. Officer O'Keefe had suffered multiple injuries, including head trauma and hypothermia. His girlfriend Karen Reed had reportedly been searching for him after a night out with friends. Prosecutors later charged Karen Reed with second-degree murder, claiming she struck John O'Keefe with her SUV on purpose and left him outside in the freezing conditions. Prosecutors cited damage to her right rear tail light to support their case. Karen Reed contends that she is being framed, alleging that John O'Keefe was injured inside the house and later placed outside. The first trial ended with a controversial hung jury, and now, as both sides prepare for the retrial of the century, there are accusations flying back and forth between the lawyers. And Karen Reed has gone to federal court trying to get the murder charge dismissed. Tonight, we are live from Dedham, Massachusetts, with all the latest as our in-depth coverage continues. I'm Vinnie Politan. Thank you for joining us tonight here on Closing Arguments. It's another big day in the Karen Reed trial. Now, I want to take a moment, though, just to take a step back. You know, we get into these cases, we get into these trials, we're in the weeds, and sometimes we forget about the big picture, about what is really happening here, right? First of all, you've got Karen Reed is fighting for her freedom. Her boyfriend, John O'Keefe, died, was killed. She's the one who's been accused of doing it. She says someone else did it, that she's being framed. And she's fighting for her freedom, for really the rest of her life, potentially, in all of this. I mean, everything is at stake for her. And she's someone who was a professor, a professional, nice family. I mean, she never, I can't imagine, ever imagined being in a criminal courtroom facing murder charges and facing the potential of living the rest of her life behind bars. But that's the reality of what's happening here. And on the other side, don't forget what prosecutors are trying to do here. They're trying to put her away. They believe she's responsible, that she took the life of John O'Keefe on purpose, ran into him with her SUV, left him in the snow to die, and then drove away. They believe she's a murderer. And if you're a prosecutor and you believe someone's a murderer, you want to put them behind bars. So that's what's happened. Let's not lose sight. You know, we get into the motions and this was said, that was said. This is the big picture of what's happening here. And then you've, of course, got John O'Keefe's family in the middle of all of it. They've lost their son. So today, the temperature is high because of everything that's at stake and what the two sides are doing here. In state court today, arguments from the defense, they were on the offensive today, pointing the fingers at prosecutors and investigators in this case. Earlier in the week, it was the other way. You know, last week it was the other way. Prosecutors pointing fingers at the defense. It's going back and forth. The fight is real. But the fight is real for the reason that Karen Reed is fighting for her life, and prosecutors want to put her away because they believe she's a murderer. And that's why things are getting the way they're getting. So what happened in court today, extremely significant, but there was action in another courtroom, in the federal court. Karen Reed went to federal court today. And this is all connected to the issue involving the first verdict or non-verdict, the deadlock jury. And they believe that Karen Reed's rights are being trampled over here. Again, she's fighting for her life. So she's fighting in federal court, she's fighting in state court, and prosecutors are trying to put her away. So today was another huge day in Dedham, Massachusetts. Joining us live outside the courthouse in Dedham is Court TV crime and justice correspondent Matt Johnson. Matt, I just wanted to kind of remind everyone that the battle here is real. Like, this is Karen Reed's fighting for her life. Prosecutors want to put her away. Two diametrically opposed forces, attorneys that don't want to lose on either side, and that's why things are getting the way they're getting. So let's talk about today. some heated moments early on.
Very heated moments, because it's very real that we are approaching the second trial, the retrial, scheduled for April 1st. Karen Reed looking very somber at times today. Moments in this courthouse behind me in state court, very tense between the judge and the defense and the prosecutor over allegations of jury interference by a trooper associated with investigating this case. Take a listen to these arguments.
I can tell you, I'm really not satisfied with your answer, Mr. Jackson. Well, put it this way. Let's say it this way. So, now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized?
Ultimately leading to the exclusion of a very, very defense-friendly defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason.
If there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial, to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion to dismiss is not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence.
Hank Brennan calling the allegations baseless and insulting on the court. It was quite a moment in court today.
What's the basis of this allegation of jury tampering? I know a lot of things were said, sidebar, things were sealed, but what came out about these allegations of jury tampering?
You know, the judge asked for those specifics, and we didn't hear them in open court. But again, this was a large motion to dismiss, and what we've seen is the redacted version of the 147 pages that were filed here in this courthouse behind me. So a lot of it is still under seal for at least us, the public.
Okay, so let's move on to what else was argued today, because as you said, this was a huge motion. This is kind of like the defense putting together everything that was done that they feel impeded their ability to have a fair trial here.
Right, you know, and we're talking about this motion to dismiss that, again, is 47 pages, nearly 150 pages to go through. And it was boiled down in the defense arguments today with two subjects. The first one was the alleged jury interference or jury tampering, however you want to word it. And then the second one was the Sally Port video, and whether video is still missing and not turned over to the defense, or about the defense receiving several pieces of video after the trial, trial number one. And they're calling that a Brady violation. Take a listen.
We can never obtain the information necessary to establish the validity of any of these videos, or whether and by whom they may have been manipulated, if at all. That at the very least, there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know through this new revelation that it was intentional. The prejudice the defense has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal.
The defense has made a number of conclusions that there was somehow videotape that was tampered with. There's absolutely no evidence whatsoever, none. It's not even speculation. There's no evidence that any videotape was ever tampered with. The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose, and again, that is a baseless claim.
So again, the defense is still asking for more video. They want all of the video from the Sally Port, from the police department over there when Karen Reed's SUV, ultimately what's being called the murder weapon in all of this, was taken into police custody. But they want a copy that includes the metadata, and that didn't get to be argued today, or at least they didn't get to it. They are going to argue that when they argue all of the remaining motions in limine on the 18th.
So when it comes to the Sally Port video, the defense theory here is that at that moment that when the SUV first arrives after it's been taken into custody, the taillight is not completely broken when it first arrives, and there are moments where Trooper Proctor is seen towards the back right of the SUV, and they're saying those are the moments where he breaks the tail light. And they're still getting video now, like video that they didn't have during the trial?
Right, they received a video clip in the fall of 2024, and then they received another video clip in January. And one of those video clips actually included Brian Higgins, who appeared to be moving his vehicles that he testified to, but then also he was on the phone making some sort of a phone call or maybe checking his voicemail. We don't know the nature of that, but the defense says that that's a discrepancy from what he testified to, and that he perjured himself. So I'm sure that will come out in the retrial. But that's their basis for saying, yeah, we haven't gotten all the video. There's got to be more. And guess who was in charge of it? Trooper Proctor.
So was there any sort of palpable reaction from Judge Cannoni? Because we saw the reaction to when the defense did things and were accused of things by the prosecution. You could read that she was not happy, grave concern, etc. Was there anything like that from the judge in response to the prosecution handing over evidence after the first trial and like still handing over evidence?
Well, it was interesting because she didn't ask for Adam Lawley to speak on that. He was the prosecutor in charge of all of the evidence in trial number 1. This is Hank Brennan that's been recently hired for the case, and he was willing to turn over additional whatever he could with the matter. He said that, he's reviewed all of the evidence turned over to him, and then that's when he's given this discovery to the defense, and that it was a mistake, it was miscategorized, and that nothing was done intentionally. But at the end of the day, the arguments turned towards the evidence in the case, Vinny, and both sides were talking about what you were just talking about, and the taillight, and when it was broken, and what Karen Reed has said over time about it being broken. I want to play part of those arguments.
Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway.
We've never, ever disputed that the light was cracked. 5:07 or so a.m. That's how it got cracked, is the point. It got cracked on the traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at or near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety, almost, except a piece was still missing. There was a piece unaccounted for. There's a big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone.
So at the end of the day, Judge Beverly Cannoni has taken those arguments, all the arguments from today, under advisement. And she asked to see some of the evidence that was presented during the trial number 1. She asked for that separately to take a second look at, because a lot of the videos, the dash cam video, the video from John O'Keefe's driveway, and also other videos of the Sally Port, those were all referenced today when determining how badly the taillight was cracked in this motion to dismiss, in these arguments. But it was also interesting, did you see who was in the gallery in front of me? Carrie Roberts, and she was mentioned by Hank Brennan today.
So when Alan Jackson is saying a piece is missing, so they are conceding that there's a piece missing, and what they're saying is that piece goes missing when she is backing out of the driveway, right, on her way to try to find out where John O'Keefe is. And it's that one piece, and the rest of the pieces, they're saying, are broken by Trooper Proctor and planted at the scene.
Correct. And that's what they were trying to explain to the jury in trial number 1. So they're sticking with that explanation, and we'll see that in trial number 2.
Okay, so super tense inside the courtroom. We understand that, right? How about outside of the courthouse? What's going on there? What's the weather like? Who's showing up? What's going on?
The weather is changing. It's raining right now. It was snowing, I believe, last week. It's been freezing temperatures. But we have seen quite a few of Karen Reed supporters out front. Out in front of the courthouse today, there was the largest numbers that I've seen over the past couple weeks. We've also seen an increase in national and international media showing back up at the courthouse because, again, after that grave concern abrupt ending 2 weeks ago, we thought that we were going to get some sort of an answer with that. Because, again, a lot of her attorneys are pro hoc vice, and people were saying that their ability to practice here in the Commonwealth was being jeopardized, that her defense team could change, that there could be sanctions on the defense. Hank Brennan yesterday was asking the court to impose a gag order in this case. So outside of the courthouse, after all of this, after federal court and the big motion to dismiss these arguments, I was once again attempting to get a comment from Karen Reed, the defendant herself, and also her attorneys. No one was speaking except for David Unetti, who is licensed in this state. Take a listen to our interaction. Your thoughts on federal court today?
No, guys.
So you think an April 1st trial date is still very possible?
We're planning on April 1st. You know, there are some things that could affect that, but we're planning on April 1st.
Any reaction to the strong arguments today about the motion to dismiss?
My daughter has assembled the most incredible group of talented, dedicated, passionate lawyers that you could bring together. And you can hear it, you can see it, you can listen to them. And they're seriously underpaid by my family. And we paid them decently, but they are still their talent just is, it's unmeasurable.
So that's a big change, Vinnie. As you know, you've been out here, you've experienced the drama in front of the courthouse, and you know that usually the defense team, from the very get-go over the past couple years, and Karen Reed herself will answer questions. This is the first time, the first couple days, that they've said no comment. And then also William Reed speaking to myself and other reporters, that was kind of surprising too, because we know that the Commonwealth plans to use his interview that he's done with local media in trial number 2, along with Karen Reed's interviews with ABC, with Boston Magazine, and local outlets. It's going to be a very different trial, but it's on track. You heard right there, April 1st.
On track for April 1st, but there are some things that could change that, right? Here we go. Matt Johnson in Dedham, Massachusetts, in the middle of it all. Thank you so much, Matt. When we come back, we're going to bring in our trial insiders. They're locked and loaded and ready. Plus, coming up next hour. Tonight on Vinnie Politan investigates the murder of 4 University of Idaho students, and now new information about DNA under the fingernail of one of the victims has been made public. Who will this help at trial? We investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan investigates tonight, 9/8 Central, only on Court TV.
It's a whodunit Hollywood story.
Monica Cimentelli is accused of plotting to kill her husband.
Celebrity hairstylist Fabio Cimentelli.
The celebrity stylist murder trial, weekday mornings, only on Court TV.
Sergeant Mechanic and I never touched any part of that vehicle.
Did you or Trooper Proctor ever go near, touch, manipulate the rear passenger side taillight area or the rear passenger side quarter panel of the defendant's vehicle?
We absolutely did not.
Troopers Buchanan and Proctor denying that they manipulated the tail light of Karen Reed's SUV. That's the accusation coming from the defense. It's crystal clear. And for them, the best proof would be the so-called Sallyport video or Sallyport videos. And this is a video that in part was shown to the jury in the first trial, but now there's more videos showing up. And Alan Jackson is claiming foul by the prosecution. Take a listen.
The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. The condition of that SUV passenger taillight at the time it was brought into the Sallyport at Kenton PD is of critical importance. And that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sallyport video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchanan admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Sallyport video? We now know that Buchanan watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding of that evidence admitted to now by Trooper Buchanan was obviously egregious. It was obviously in error. It was obviously calculated.
So let's take a look at the video. It was presented to the jury on the left, which is not the way. Left is right and right is left on the left-hand side, and on the right-hand side, right is right and left is left. But the jury was shown what was on the left by the prosecution. Inverted, misleading video. But now Alan Jackson defense says they didn't get all the video. There's more out there. Let's talk about it. Joining me tonight are Karen retrial insiders in Massachusetts, attorneys Wayne Dennison and Joseph Krowski Jr., Karen Reed supporter Nick Rocco, and YouTube host Kevin Lenahan. Great to have everyone here. Nick, I want to begin with you. Lay down the foundation here from the defense perspective. What is the video that they did not get in the first trial that they now have? And is there more video they believe exists that they do not have possession of?
Well, the Commonwealth was in possession of all of this video footage as early as February of 2022 and then June of 2023. And one of those videos being when they actually pulled the vehicle into the Sally Port, where you can see the backside of her vehicle. But the issue with it, like most cameras at CPD, is it's all blurry and all grainy. And the only camera that they seem to replace is this one right here, the one that we're looking at, the inverted video. So every camera around CPD is blurry and fuzzy, but they like I said, they only removed this one. And it's important, this one, because they all claim that to not go near her right taillight. And as we can see, when you flip this video around, Michael Proctor actually comes directly out of that corner where her right taillight was. And today, Hank Brennan showed us a video from January 1st of 2022. And if you look at the timestamp is yellow, okay? And in the video in the court trial, the timestamp is blue. Now, there's three issues with that. One, no metadata attached to either one of those videos that was shown. Number two, you have so you have the metadata, and then with the inverted video, this came, I believe they said May of 2024. Yuri Buchanan was looking at it. He actually takes a picture. You can see the flash. He takes a picture of the front of the vehicle. Did he take a picture of the taillight? Nobody knows, because none of these photos were turned over. So, I mean, even in this video right here, you have a blue timestamp. The one that Hank Brennan showed us today has a yellow timestamp. So if these were taken all at the same time and from the same camera, it would have the same data on it. So I don't know what to say. Metadata would prove it all, I believe.
Okay. Kevin, is there an innocent explanation for any of this?
Yeah, it was provided. We got the video from a month before, and it showed that the inverted video was inverted a month before, and the grainy video was grainy a month before. So this is just how they recorded. And this whole Sally Port thing is really the dog that don't hunt. We're supposed to believe that Michael Proctor, for some reason, it was unusual that he was looking at the damaged taillight. What else should he be looking at? And that he handed it off the pieces, cracked it, even though it's not evidence. It's in the video. He doesn't seem to touch it, but somehow he cracked it, pried off pieces, handed it to a ghost who took a time machine to get back to the crime scene miraculously before the CERT team arrived and WBZ News arrived. I mean, none of this stuff just makes any sense. And as Hank Brennan did, just let's stop to say too, both these lawyers were brilliant today. I mean, it was just amazing to watch these guys in action. But Hank Brennan made clear that taillight was broken all day, starting at 5:08 from numerous images and in Karen Reed's own words. She describes it plucking pieces out and missing pieces and thinking it wasn't going to work. So this is really the dog that doesn't hunt.
All right. I've got great lawyers here, too, as well. Wayne Dennison.
Absolutely.
Yeah, I'm setting it up for Joseph Krowski Jr. because he's like, I can see him. He's getting riled up already. But Wayne, I don't understand this. When I practiced in New Jersey, we were prosecutors before the trial. You get all the discovery. Here's everything. Why is the defense in this case getting stuff during the trial and after the trial? That's insanity.
They shouldn't be getting stuff during the trial and after the trial. And I think there was a frank admission by Mr. Brennan today that this was a mishap. This shouldn't have happened. The question is this error, and it is an error, is this error going to be ultimately deemed harmless by the judge? And my expectation is that she will deem it harmless.
Joseph Krowski Jr., is it harmless? The defense is saying this is exculpatory.
So, yes, it's harmless. Just to be clear, really the point of contention is an external camera that captured some footage at the moment that Karen Reed's vehicle was brought to the Canton Police Department. The Sally Port video was actually produced, and it was produced at trial. To answer your question, Vinny, you've tried cases, I've tried cases. The crime scene was at 34 Fairview, and the defense theory of the case was that Karen Reed may have hit John O'Keefe but didn't intend to do so. I've tried homicide cases, and I will get surveillance video from the crime scene. In relationship to the police department, maybe I'll get surveillance video of the booking procedure, of recorded interviews of witnesses, of them processing evidence. But you don't get every single camera from every single vantage point of the police department, hallways, exterior, interior. Trooper Proctor, to his benefit, was the one that brought it to Alan Jackson's attention at the first trial that there was exterior footage. And I guess the argument is, if you were trying to hide the ball, you'd just hit the delete button. You wouldn't bring it up in your testimony. But the real question is, and the analysis the court has to take is, A, whether or not it was exculpatory, and B, whether or not it was intentionally withheld or destroyed. It certainly wasn't destroyed. Some portions of it might have been negligently withheld. But to get to Kevin's point, Attorney Brennan went through video footage at Meadows. It showed that taillight essentially damaged. Karen Reed, through her own mouth, said the taillight was damaged so much so she could see the bulb. This is all before getting to the Canton Police Department. They had video footage from William Reed's house of that car being put on a wrecker. The taillight was damaged. They had video footage from 8 o'clock in the morning of a well-being check. The taillight was damaged. All of that took place while Trooper Proctor was home eating Cheerios long before it got to Canton. So there's not going to be a showing that it was exculpatory.
All right, that's state court. When we come back, we'll move to federal court, and we'll also take a listen to what one of the jurors from the first trial had to say about whether or not they reached a verdict on counts 1 and 3.
Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service.
That's how the first trial ended. That final note came from the jury, and then she finishes reading it, the judge, and within 2 seconds is dismissing the jury and declaring a mistrial. Now, Karen Reed and her attorneys going to federal court on a habeas motion, trying to get some of the counts dismissed here because they believe the jury reached a verdict on 2 of the 3 counts. Here's Karen Reed's father after court today.
What are your thoughts on federal court, how the arguments went today?
I thought the arguments were very thorough. The judge seemed to be invested in the arguments, so we're very hopeful. I didn't sense anything that was problematic. I thought he was trying, and he will make every attempt to resolve what is a conflict in this case, that Karen Reed was acquitted of the 2 serious charges, and we need some type of remedy of that. And it's the federal requirement against the double jeopardy. And double jeopardy with murder is just, it's something that needs to be resolved. So we're hopeful, we're prayerful, and we thank everybody for being with us on this long journey.
Let's take a look at the charges again. Okay, there were 3 counts. Count 1 was second-degree murder, life with parole. That was the most serious. The second count, manslaughter while under the influence of alcohol and lesser includeds. That's 15 to 21 plus lesser includeds. And then count 3, leaving the scene of personal injury, 2.5 to 10 years. Now the defense is saying they reached not guilties on counts 1 and 3, and we're debating counts 2 and the lesser included. NBC 10 in Boston sat down with one of the jurors from Karen Reed's first trial who spoke about their deliberations before the mistrial was declared. Take a listen to this.
It did not appear, at least to myself, that she intended to commit murder. The other piece, which was the leaving a scene of an accident, also did not appear very clear, and therefore everybody voted for those two charges as not guilty. Unfortunately, we didn't get clarification early on that we could look at each charge individually and independently of each other. If we had done that, then I don't know where we would be or if we would be talking today.
Still with me are Karen retrial insiders, Wayne Dennison, Joseph Kraske, Nick Rocco, and Kevin Lenahan. All right, Nick, you were there today. What did you think about how things went? Could you get any sort of read on how it was going?
So Martin Weinberg, he was up there for about the first hour making his argument. He put before the judge about 15 different cases that obviously was in favor of his argument. And then the Norfolk County attorney stood up. He was probably talking for about maybe 30 minutes. He had 3 cases that would go for his side, 2 of them which actually Martin Weinberg used in his argument as well. And then the judge pretty much looked at both of them and said, listen, I know there's an April 1st case coming up. I'm going to make a decision very quickly. And the reason behind that was because he said if anybody who is not happy with his decision can basically file an expedited appeal. I do find he asked both sides pretty fair questions, basically to try to convince him as to why he should do what they're doing. One thing the state did say was if they did want to poll the jury, they would like it to be in state court. And Marty Weinberg said if they were going to poll the jury, he would like that judge to do it in the federal court.
Fascinating. Okay, so it's about inquiry. Kevin Lenahan, do you have any doubts in your mind that this jury reached not guilties on 1 and 3?
So I think one of the things, I'm going to be quick here so we can let the lawyers go on this one because this is a really interesting discussion. But, you know, as far as figuring out, it's really kind of difficult to get to even trying to weigh seriously charges 1 and 3 until you come to a unanimous decision on 2. Because in 2, that's where you decide that it actually was Karen's Lexus that struck John. And once you come to that decision, then you can go back and see, did she leave the scene of the crime and was there any malicious intent involved? I'll just end it there.
Sure. Joseph Kraske Jr., I'll start with you on this. You're going to federal court. It's sort of an unusual move. We don't see it all the time. But what are your thoughts about this move by the defense, number one? And does it have some level of credibility if they're talking about things like double jeopardy, which is more of a constitutional concern rather than the local Massachusetts law on how a jury has to fill out a piece of paper?
So just quickly, you put up the potential penalty for OUI manslaughter in Massachusetts. It's actually a minimum mandatory 5 years with a maximum 20 years, not 15, 21 and a half. I think your viewers should know that. So this is a habeas corpus petition. And translated to English, we've got the body. And what it means is the defendant is pressing a federal constitutional claim. In this case, double jeopardy. And typically it's reserved post-conviction while the person is in custody. The argument that Marty Weinberg made is because the defendant is on bail and her liberty is restrained, she is essentially in custody. I will say the success rate is only about 5 to 10%. I've tried cases. I've been before Judge Saylor, very smart, very thoughtful. It's really an uphill battle, and I can't see him disturbing not only the decision of the trial court, but we have here the benefit of a Supreme Judicial Court opinion. So he'll be thoughtful, he'll read it over, but I don't think that it's going to go anywhere.
Wayne, what are your thoughts here? And what do you think is justice here? Should there be an inquiry, a simple inquiry, to find out if, in fact, these 12 jurors all agreed that she was not guilty of 1 and 3?
I don't do this a lot of times, but I'm going to have to tell you that I pretty much agree with Joe across the board on this, from the fact that Judge Saylor is, in fact, a very good jurist, to the notion that this is going to be a difficult row to hoe for the defendant. One of the things that doesn't get talked a lot about, if you listen to that jury note, in every instance talking about the deadlock, they use the word charges with the S, with the plural.
Well, aren't there lesser includeds in count 2?
Yes, there are. There are lesser included in count 2, but a regular view of what the jury was saying was that there were multiple charges that hadn't been determined. So I think this is going to end up...
Well, here's where I have the problem, right? Because I'm a simple guy. I just like the truth and justice, right? Like, I'm so shocked that in Massachusetts there's no mechanism to, or wanting to know, like the inquiry. Let's find the facts first, then we'll decide what to do with it, because you've had 4 or 5 jurors saying we all agreed, but nobody cares. Like, nobody cares about it. I'm just shocked. No. Anyhow, no, I am, Joseph. I'm sorry. I can't agree.
We do care.
I don't know. They care if there's an allegation of racial prejudice. They care. They'll reopen it. But if there's potential double jeopardy, they won't. I think that's silly. But we've got to do this another time, like Friday. Let's do it Friday.
If it's extraneous. Extraneous.
Gotcha. All right. Thank you, gentlemen. When we come back, something else you need to know. Tonight on Vinnie Politan Investigates, the murders of 4 University of Idaho students in the middle of the night. The crime shocked the nation. Tonight, we look at one of the surviving roommates and how her testimony will impact this upcoming trial.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
An Iowa man is found unconscious after crashing his car. He asked police to check on his girlfriend, recalling flashes of violence. Now he's on trial for her brutal murder.
The Visions of Violence murder trial, weekday mornings on Court TV.
Today. Time to reveal something else you need to know tonight. Let's take a look at the big board, and it's the Skelton brothers have been declared deceased. Their mother brought a case in probate court for little Andrew, Alexander, and Tanner, who in 2010 went missing while in the custody of their father. I want you to take a listen to the judge's ruling in this case.
Alexander William Skelton, Andrew Ryan Skelton, and Tanner Lucas Skelton have been missing since November 26, 2010. Given their undisputed disappearance for over 14 years, the statutory presumption of death applies. The presentation of evidence, however, does not present clear and convincing evidence that John Skelton murdered these children. It is with the gravest of condolences that it is ordered Alexander William Skelton, Andrew Ryan Skelton, and Tanner Lucas Skelton are presumed to be deceased as of November 26, 2015, in accordance with MCL 700.1208, subsection 2.
So they've been declared deceased, but you heard that she said there was not clear and convincing evidence that John Skelton was responsible. Interesting twist. We'll continue to keep our eye on that case. Right now, I need you to keep your eye on the television screen because we have a missing child. This is Autumn Sierra Fagan, just 16 years old, missing out of Baltimore, Maryland since February 25th. If you see Autumn, take a look at her picture now. If you see Autumn, pick up the phone, make a call, make a difference. You can call 911, 1-800-THE-LOST, or you can call the Baltimore City Police Department in Maryland. That phone number's on your screen right now. Let's see if we can get Autumn to a safe place tonight. Don't go anywhere. We've got another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.